Hey guys, it's Catherine Morgan here, founder of The Money Panel, and welcome back to my YouTube channel. So in today's video, I'm going to be covering one of those subjects that we kind of know that we really should probably get around to making that will, right? And that's why you're here, to learn more about how do you go about that process? What are the different options available to you? Do you do a DIY will, or do I go through a solicitor? What are my options? So in this video today, I'm going to be covering my top 10 tips. I'm going to be covering exactly what a will is, what is the responsibility of an executor, and how do you go about choosing an executor. I'm also going to be covering off power of attorneys and the importance of power of attorneys and how to go about making one. I'm also going to talk about the 4 different ways that you can write a will, because there are DIY versions, or you may wish to go and seek expertise and help through a solicitor. So I'm going to talk you through 4 of the most common ways that you can make a will. I'm then going to talk about the importance of making a will and why you need to make one, who needs a will, and some important things to include. So stay tuned. In this video, you're going to be hearing about those top 10 tips. So in today's training, we're going to be talking about how to make a will. Now, this is a conversation that I have on a regular basis with many people that I coach. That we sparked off quite a major conversation about this in the Facebook group just a few short weeks ago. So I thought that I would take this opportunity to provide you with some training around making wills and how you can protect your family. Now, it always interests me how we don't like to talk about taboo subjects. And death is one of those taboo subjects, right? And I know right now there's like lots of fear-mongering and scaremongering going on about the coronavirus, which is something that's going on globally for all of us right now. And people don't like talking about the kind of what-if scenarios, the what could happen. And I think when it comes to making a will, it's one of those things that, I mean, when would you realistically have a conversation about wills? You know, it's not something that we often talk about very openly with friends over dinner or even with our partners. And if you're living by yourself, then again, it's not really something that would necessarily come on your radar, and we tend to just put things off. So I'm really excited to bring some training to you today, just to talk you through the basic principles of will writing and power of attorney. Now, just to put this into perspective, we only made our wills back probably, did we make our wills pre-children? Do you know, I actually can't remember. I think we made our wills very close to when we got married. No, that's right. We made our first will when we bought our first house together. When my husband and I, we weren't married, we bought our first house together, and that's when we made our will. And I remember it was when I was working at the bank. We used to actually write people's wills for them when I was working at the bank. And I remember going to visit people at their homes and sitting down and having conversations with them about their estate and what they wanted to do. And often it formed part of the conversation around inheritance tax planning. And a lot of people think that, well, you know, I'm young and fit and healthy, I don't need to make a will. And I would definitely say that making a will is relevant, whether you're single, whether you're married, whether you're not married, and you're in a relationship, whether you're in a civil partner relationship. All of these factors have their risks if you don't make a will. And I'm going to talk through some of those in the training today. So really, you know, there are 2 certainties in life, death and taxes, and we should be talking about this more openly. Now, let me first of all just talk about what exactly is a will. Now, a will is a written legal document, and it sets out your wishes as to what you would like to happen in the event that something happens to you. Now, in order for a will to be legally valid, it needs to be in writing, it needs to be signed, and it needs to be witnessed by 2 independent witnesses. So what that means is that they can't be beneficiaries within the will to witness the will. So for example, let's say you've left some money to your best friends. You can't have your best friend witness that will because there's kind of a bit of a conflict of interest. So they have to be independent witnesses. And they would witness the will once it's been drafted, and I'll talk through the process a little bit later in this training. And you then need to choose executors. So an executor is who is responsible for gathering together all of the information about your estate if anything happens to you. They would apply for what they call grant of probate. They would calculate any potential inheritance tax that's due on your estate. They would pay the inheritance tax on your estate. And inheritance tax, I believe, unless the rules have changed, has to be paid within 6 months. And often this is a problem, actually. This is, when I worked at the bank, this was often a big problem, is that if there is an inheritance tax to pay, then the beneficiaries have to pay that tax within 6 months. Now, sometimes they don't get access to the estate until later than 6 months, because maybe the estate is mainly property and they can't sell the property to pay the inheritance tax bill. And typically, beneficiaries will look at taking out loans so they can pay that inheritance tax bill first. And I know we're going slightly off topic here, but it's something that you have to think about, because if all your estate is predominantly in property and there's no free cash, then that can cause beneficiaries problems in terms of paying inheritance tax. Now, not all of you will pay inheritance tax. Your estate won't pay inheritance tax. It depends on what your estate is worth. But it's definitely something to consider if your estate is worth more than the inheritance tax threshold, which I won't go into in today's training. But that would be what your executors will be legally responsible. So they will be legally responsible to kind of total everything up, apply for the grant of probate, and calculate any potential inheritance tax that is due. So if you think about it, when you come to make a will, and I'll talk you through the steps, the first thing to consider is who are going to be your executors on your estate. It's a fairly simple process, but a lot of people procrastinate about this. And what I would think about is, who do you implicitly trust? Who do you think would be responsible enough to make those decisions? Now, obviously, if you have a will, they're really just administering your wishes. So they don't necessarily have to make decisions, but they have to just be capable and responsible people. So what I would do is grab a piece of paper and think about, who do you know that's capable and responsible in your life? Who would you implicitly trust? And if you really can't think of anybody, then sometimes people may choose a solicitor to be maybe one of those executors. It could be, a solicitor could be one executor alongside a family member or a friend. But be mindful that solicitors obviously will charge for that service. Now, if you're going to go down that route, my suggestion would be is to ask that solicitor whether they take a percentage of the estate or a fixed fee. This is really important. If you choose a legal, like a solicitor to be your executor, certainly in the past when we used to make wills in the bank, the solicitors would take a percentage of the estate. Now, if your estate's quite considerable, that's a considerable percentage. If they take 1% of your estate, that can be quite considerable. So certainly if you're going to go down that route, my suggestion would be to ask the solicitor whether they can do it on a fixed fee basis or a percentage. And if they only do a percentage basis, just be a little bit mindful of what that could actually work out to be. So that's what you would need to do, is to choose at least 2 executors to legally be responsible for administering your will, applying for the grant of probate, totaling everything up and doing all the necessary legal work that is involved when somebody passes away. So that's the first thing. In terms of beneficiaries, when you make a will, most people, and I'm saying most people, there will be some of you that will have differentiating circumstances, but for most people, they would like their partner or their spouse to inherit their estates. And then if anything happens to both of them together, or on the second death, it would then go perhaps to children. And if there are no children, then it may go to family members, maybe some friends, maybe some charities in there as well. But I'm sure that all of you have got some kind of expectations as to who you would want your assets to go to if anything happens. Now, if you don't have a will, you fall under the rules of what they call intestacy rules. Now, I won't go through all the intestacy rules because there are lots, there's like a flow chart, and I'll pop a note in the show notes of the podcast to a really good diagram that shows you what would happen if you didn't make a will. But let me just give you a couple of examples. So if you are single and you're not married, and you don't have any children, then your estate would go to your parents. If your parents aren't alive, it would go to brothers and sisters. If your brothers and sisters aren't alive, it goes to nieces and nephews, then grandparents, aunties and uncles, cousins. And if there's none of those family members around, it goes to the crown. Goes to the crown. Goes to the, like, I just think that's like, goes to the government. That's one reason why you need to make a will. If you are single and obviously you do have children, then that will be shared equally between the children. If you are married, then if the estate is worth more than 270,000, then your partner, your spouse, would get everything. This is on marriage. This is not if you're unmarried. So if you're married and your estate's more than 270,000, which for most people it will be, because our houses are generally worth in and around that area on their own, based on average house prices in the UK. So your spouse would get everything. If you have children, then your spouse would get up to 270,000 and half of the remaining estate, and then your children would get the other half. And that would be held in trust for them until they reach the age of 18. So, you know, that may be what you want to happen. But the thing with intestacy rules is it's complicated, it's costly. There's huge delays with trying to, and I'll talk through a little bit about the process in a second, but intestacy rules are not good. They're not good. And for the sake of literally like £150 to make a will, I would highly recommend that you consider that. But there is like a whole flow chart of in what situation, if you're married, not married, have children, don't have children, that things would happen. And I'll pop a link to that in the podcast show notes. Now, if you're not married, this is the most important thing for you to do, because there's a massive misconception that people think that because they're living together, even if they've lived together for like 20 years, that legally you're entitled to the other person's estate. And that's not the case. There is no legal entitlement for unmarried couples. If you know anybody who is living together that is not married, please tag them in this video or share this podcast interview with them, because it's one of those areas that is hugely misunderstood. And I've heard of lots of examples in my Facebook community of people that have been unmarried with children and have been left with nothing. They're not entitled to bereavement payments. They haven't been entitled to some pension benefits, depending on the type of pension scheme that your unmarried partner has. If they have a final salary scheme pension, often the beneficiaries, the automatic beneficiaries, are spouse or children. And so therefore, if you're not married, the pension scheme will not pay out to an unmarried partner. So don't make the assumption that because you've been living together for 20 or 30 years, it doesn't matter. There's no legal, what's the word I'm trying to think of? Like, there's just no legal rules to say that you're entitled to anything. So the next thing I wanted to talk about is, so we talked about a little bit about what executors do, and we talked a little bit about potential beneficiaries in a will. Really, you can leave your assets to whoever you want to. And there may be certain things that you want to leave to particular people. So for example, one of the areas of your will be like personal assets. So things like wedding rings, maybe your wedding dress, maybe you've got items in your home that are worth of a particular value, either financially or just sentimentally, that you want to leave to specific people. Those sorts of things can go in your will. It may be that you have specific requests about your funeral arrangements, whether you want to be buried or cremated, what songs you want to have played at your funeral, all sorts of things that you can, again, specify in your will. And I know this is super scary to think about. And I know this is the last thing you want to talk about is, oh, what kind of songs do I want to have at my funeral? But seriously, the more you can think about the what ifs, the easier it is for everybody that is left when you're not around. And let's face it, death is one of the most traumatic experiences that we go through in our life. And I'm sure many of you will have experienced this already. And the last thing you want to have to do is to try and make decisions about things like that, when actually the person living can just think about what their situation what they would like to happen to make your job easier. Now, for those of you who have, I'm just going to touch very quickly on, if those of you have an existing will and you're listening to this thinking, actually, there's a couple of changes I need to make to my will, then you can do what they call a codicil, which is CODICIL, a codicil. And that's just a fairly minor amendment to a will. It doesn't necessarily mean you have to rewrite your entire will, but if you've got small things you want to change, then you can do that through a codicil. And I would suggest that you go back to whoever wrote your original will and just say to them you've got a small amendment to make, and they'll be able to draft that amendment. You would sign that, job done. Now, the other scenario to think about in terms of changes is marriage and divorce. Now, if you get married, then any will that you have in existence is void, i.e., it's treated as if there is no will. So that's what happens on marriage, on like a remarriage, for example. However, divorce is not the case. So if you get divorced, technically your ex-spouse could try and claim some benefits from the estate. It's unlikely, but it's possible. And the way that the law works is that your ex-spouse is treated to have predeceased you. So if everything goes to your ex-husband and then to the children, and then you divorce, the way that the law works is it treats your husband as if he's already predeceased you. So like he's not alive, and therefore everything would just go to the children. But there have been some cases where this hasn't happened. So my suggestion for any of you that have been through a recent divorce or who are going through a divorce or separation is to make that one of the first things that you do once that divorce is finalized. You can be having those conversations now, and a good solicitor would already be talking to you about this. But make sure that you strongly consider rewriting a brand new will, because it just makes things much simpler and clearer. So in that situation, if when you go through a divorce, then it will just be, what do you want to happen to your assets now that you've divided your assets up? And as I say, a good solicitor would normally talk to you about that, because obviously when you go through divorce, there'll be some pension sharing conversations about, are you going to be accessing some of his pension benefits? There may be some maintenance benefits that you're wanting to consider, and therefore you may need to be thinking about whether to put some life insurance in place. So if anything happens to your ex, that maintenance payment could continue. All of these things to take into consideration. So those are the few tips around changes. So if it's a small amendment, you can just do a codicil. You don't need to make a brand new will. If it's a major change, you will need to make a brand new will. If you remarry, then your will would be void. And if you go through a divorce, make that one of the first things that you do is to make a new will. Okay, so let's talk about, we talked about the laws of intestacy. So we talked about what would happen if you don't have a will. We talked about if you're an unmarried couple, you don't have any legal rights, and therefore you need to consider making a will so that then you can potentially leave assets to the surviving partner. This is particularly important with property ownership as well. And this question comes up quite commonly as, well, what would happen if we're not married, but we have a property together? Would I be forced out of the house? So legally, you'd have to go through the process of actually applying for you have a financial benefit in that property. And it depends on how you own that property, because there's two ways of property ownership, one called tenants in common and one called joint tenancy. And depending on how you own that property will depend on the legal rights. So for example, if you have joint tenancy, then you're both legally you share the ownership of that property equally. If it's tenants in common, then you have a percentage of ownership. So normally it's 50-50, 50% to one and 50% to the other. So depending on how you own your property will depend on your legal rights. So again, another reason why it's particularly important if you're not married to consider making a will. Okay, so one of the questions that's come in around this training from Becca Heaps is that Becca is not married but living with her partner. who is not the father of her children, would everything go, and the question she's asked is, would everything go to my children or to my partner without a will? So Becca, in that situation, when you're not married and you have children, then the likelihood is that your estate would go to your children if you don't have a will. And again, I'll pop a link to the flowchart you can have a look at. There's also a link on the Government UK website. You can actually fill in all the details of your situation and it will tell you where your estate would go. But what I would suggest in that situation for anybody who's in a similar situation to Becca is just for the sake of £150, make a will, because your partner may want some legal rights in terms of living in that property. Depending on the age of the children as well, you may want to think about guardianship. Now let's talk about guardianship for a moment. Guardianship is one of the biggest procrastinating reasons why people don't make a will. And I totally understand this, because who wants to think about what would happen if you weren't around? But think about your responsibility as a parent. Your responsibility as a parent is to, obviously you want to look after your children. And by not making a will, I believe, is not particularly responsible. And I know some of you might not want to hear that, but just being really honest with you. And therefore, I've written a few bullet points out for you as to how I would go about choosing a guardian. And this is the process that me and my husband went through when we made our wills. Now, the reason this is important is because if you do have children, and let's just talk about this, right? Worst case scenario, if you and your partner are in a car and something happens to you both together, who would you want to look after your children? And the things that I've written down here for you to think about is I would sit down with a piece of paper and I would think about, okay, so first of all, who are your potential options for guardians? Now, these are like people who really absolutely love everything about your kids. Like, in your mind, who adores your children? I think that's really important. I know it's like a really obvious thing to say, but who would be prepared and willing to look after your children and give them love? Because at the end of the day, that's what you want for them, right? Think about your own values as a parent. This is a big one. So literally write out your values on a piece of paper. As parents, what is important to you about being a parent, about your children's future? And then I would think about, look at your potential guardians and think about what are their values. If you have conflicting values, I don't know about you, but I would not be comfortable for my children to live with anybody who had conflicting values. So that's a really strong, powerful exercise to do. Think about location. Where do they live? In an ideal world, in that situation, you want your children to have as least kind of upheaval as possible. And again, depending on the age of the child will depend on emotionally how they cope with this. But for me, if anything happened to me and my husband, I would want my children to stay at the school that they're at, to have as least kind of like upheaval as possible. And it's an awful thing to think about, I know. So I think, right, who lives fairly locally so that the children could still continue to go to school? Think about the age and the health of those guardians. Ideally, they want to be of a similar age to you or younger. However, don't rule out parents or grandparents if you can't think of anybody else. Because maybe you choose them initially as your guardians, but then you review that. You know, if your parents are aging or their health is deteriorating, then you can change your guardians at any time. But don't let that be the reason for you not to make a will in the first place. Just think about currently, as of today, who would make the best guardians for my children? And then have a conversation with them about it. Ask them. I think this is a really important step. Ask them whether they're willing. And think about their own situation. Do they have their own children? How do their children get on with your children? And if at the end of all of that, you still can't think of anybody, then just choose somebody who you think right now, as of today, if anything happens to me today, who would I want to look after my children? Make that decision and then review it later. But don't let that be a reason to put you off. So one of the questions that's come in around this from Fiona Alcott is, It may seem like a bit of an odd question, she said, but we don't have kids, but we have a dog. Should we include something about what would happen to our dog? Absolutely. Puppies and kittens and animals are like children, right? So we have to make choices that if anything happens to me, who's going to look after our animals? So yes, absolutely. That's the sort of thing that you can put in your will, that if anything happens to me, maybe, if anything happens to one of us, the other partner can obviously continue to look after them. But if both of us die together, or, on the second death, if our animals are still alive, we would like it to go to a particular person, or maybe worst case scenario, you've got a particular shelter that you'd like to choose. And again, that could be made, you can make provisions for that in your will. So yes, 100%, anything that's valuable to you, personal possessions or animals or children. That sounds funny when I've just said it after personal possessions. Your child is your personal possession. But they are, right? They're really important to us. And I know that this can put a lot of people off. So don't let that make you not make a will. Just make the best decision based on what's the best scenario as of today. And as I say, that can change. Okay, so we've talked about guardianship. We've talked about what is a will. We've talked about executors. We talked about making changes to a will on divorce, remarriage, or small amendments that you need to make. We talked about the rules of intestacy, what would happen if you didn't make a will. We talked about unmarried couples and relationships. Let's talk a little bit about power of attorney. This is another conversation that typically comes up at the same time as making a will. And I'll talk you through at the end of this what different methods there are to make a will, some average costs and top 10 tips. So in terms of a power of attorney, think of this as like a living will. Okay, if you are unable to make decisions, what would you want to happen? Now, this could be because of ill health. This could be because of things like dementia or Alzheimer's, where you're unable to make a decision. But it could also be just because you've maybe had an accident. Maybe you're in hospital for a couple of weeks. You might be in hospital for a couple of weeks and still be able to talk, but you might be in an induced coma, or anything could happen where you can't make any decisions. And this is where a power of attorney comes into place, where you would want, in a living situation, i.e. you're still alive, but you're unable to make decisions around your finances. So let me give you a scenario. So let's think about, let's say you've got bills coming out of your sole account, okay? And your wife or your husband or your partner won't have legal access to that account because it's in your sole name. Whether you're married or not makes no difference. If you've got your main bill account in a single name and something happens to you and you're alive, but you're not able to make decisions, then your spouse or partner is not able to make any transactions on that account. So this is where a power of attorney could be used, so that would give your partner or wife or husband legal access to administer and look after those accounts until you're maybe capable again, or you may never be capable again if it's a significant long-term illness. So there's two types of power of attorney. There's one that's called the health and welfare, and that's all about medical intervention. And then you've got one that deals with property and financial affairs. So that's, paying of the bills, for example, maybe selling the house. So you have two types there. And when you draft a power of attorney, then you'll consider both of those scenarios. And that could even be things like medical intervention. Like, do you have any particular views as to what decisions the doctor should make in certain situations? And again, it's not a very nice thing to think about. There's a lot of controversy around this. Even things like with organ donations, should everyone be automatically enrolled or not into organ donations? Should you be resuscitated? If you're in a certain state. So, quite touchy subjects and quite controversial subjects. But power of attorney is not just for people who are in their 70s and 80s. Power of attorneys can hit people. People can need them if they're in a car accident, for example. So don't necessarily think that power of attorneys are not relevant for you if you're fit and well and healthy. In fact, it's the best time to be making a will, and drafting and writing a power of attorney, so that if that situation happens, you can do something about it. Now, the way that a power of attorney works is you would have one drafted, and then you would register it with the Office of Public Guardian. Now, if you don't have a power of attorney, you have to go through the Court of Protection, and the Court of Protection route is way more costly, because the Court of Protection will actually appoint a deputy to deal with the financial affairs, and that can be considerably more costly than if somebody else that you know is doing that for you. So again, another reason why not to delay thinking about writing about a power of attorney. Now, one of the reasons why many people don't do power of attorneys is because of the expense. And typically a power of attorney would cost you somewhere in the region of between £400 upwards, depending on the complexity of your situation. But again, I always think £400, like, you would very happily, easily spend £400 a month on food. I certainly do. I spend at least £400 a month on food. So for the sake of a month's worth of food, I would rather have that situation dealt with than anyone who's dealing with my estate from a wills perspective, or if I'm injured or unable to make decisions, I'm not putting that pressure on my family. One of the other questions that I wanted to answer as well around this is, and I'm going to bust through a couple of questions here now, and then I'm going to come on to talking about 10 tips and costs of all of these things, and how to go about making a will. One of the common questions I get is, well, what happens if we have assets abroad? Now, if you have assets abroad, then the general recommendation is that you make a will in every country in which you hold assets, because the rules of inheriting are different in different countries. So let's say you have a property in France and a property in the UK. You should ideally have a French will in place and a UK will, because as I say, there may be differentiating rules in both countries. So that's certainly something to consider if you've got assets in other countries. And if you are living in the UK and maybe your partner is from France, let's say, then it's the country that you're residing in when you die. So even if you're not born in the UK, like, don't let that put you off. Don't let that think, oh, maybe the rules are different for me, because if you're a UK resident and you die in the UK and you have assets in the UK, then your estate will be distributed in accordance with UK rules. And obviously, if you have international assets, they will be distributed according to the rules of those countries. So that's definitely something to think about. And the other thing that I get asked about is, well, what happens if my children are grown up now? Should I still make a will? Absolutely. The only thing that wouldn't necessarily apply there is guardianship, because they're independent financially. They're not financially sort of relying on you. But absolutely, you should still make a will, even if your children are not financially or dependent on you anymore. Okay, so the next thing I wanted to cover is, what are the steps? What are the ways that you can make a will? And there are really 4 ways that you can make a will. The first one is to make one yourself. The second is to use a will writer. The third is to use a solicitor, and the fourth is via a charity. So let's just talk about those 4 main areas. And I don't know, I'll be interested to know, actually, from those of you that are listening who have a will, which route did you go down? Did you make it yourself? Did you use a solicitor? Did you use a will writer? Or did you use a charity? So let's talk about making one yourself. So if you made a will yourself, you can literally go into WH Smith's and buy a will writing pack. Now, this is the cheapest way to make a will. And actually, if your situation is very straightforward and you're procrastinating about this right now, that is an option. It isn't something that I personally would recommend, because it's probably a little bit risky. The reason it's risky is because if you haven't done it correctly, or maybe it's not been witnessed correctly, or you've missed something out, then it can be a costly mistake. So what I would say is, if you're really avoiding doing it because you can't afford to use a solicitor right now, that would be your best option. And I'm sure if you Google how to make a DIY will, there'll be tons of like YouTube videos and things like that. Obviously, make sure they're coming from a reputable source, but there's lots of guidance available through lots of different websites. So if you're in that situation and you can't financially afford to do it through a solicitor, then definitely a DIY will is better than no will at all, in my view. The second option then is to use a will writer. Now, the benefits of using a will writer is they are cheaper than a solicitor, okay? However, they're not regulated in the same way. So if you ever had a complaint or anything like that, then they're not regulated, whereas a solicitor would be regulated. So if you're going to go down that route, and I'll be really honest with you, we used a will writer for our wills. And we used a will writer who was a member of a professional organisation. They'd been a will writer for 40 years. So we were very comfortable that that's all they did. They were an expert in what they did. They hadn't just set themselves up as a will writer, which can happen, like a year ago. They were highly recommended by lots of people. So if you're going to go down this route, my tips would be to go and check out and make sure that they are a member of a professional organisation. And the two organisations that they need to be members of, the first one is the Society of Will Writers, and the second one is the Institute of Professional Will Writers. So if you're going to go down that route, ask them that question. Are you a member of one of these professional organisations? Get some recommendations from other people around you. Ask them what their experience is, maybe see if they have any qualifications as well. And that will just give you, a little bit more of a bit of a backup to feel certain that you want to go down that route. And typically they will be cheaper than going down the solicitor route. So the third option then is going via solicitor. Now this in my mind is probably the most, it's the least risky option. Because particularly if it's a solicitor that deals with probate, wills, estate planning and inheritance tax, and if you have a complicated scenario, maybe you've got children from a previous marriage, maybe you've got lots of different assets, different ownership, maybe you've got certain particular views around some of those areas, maybe your estate is worth a considerable amount over the inheritance tax threshold, then I would definitely go to a solicitor because you'll want to consider the most tax efficient way to leave your will to the appropriate beneficiaries. And I'm not going to go into inheritance tax planning today, but there are definitely some considerations to think about with inheritance tax. So using a solicitor is your third option. And then the fourth option is to go via a charity. Now, this can be really, you can be quite clever around this. A lot of wills can be made at particular times of the year through what they call will aid. Now, will aid is normally around October, November time, where you can actually approach specific charities, and in conjunction with local solicitors or national solicitors, they will work with that solicitor to help you draft your will, and then you make a charitable donation towards the cost of that. And there are lots of charities that participate in this, charities like Cancer Research, Stroke Association. So that could be something you might want to go and Google, is charity will aid. Now, in and around October and November for the rest of the year, there are also lots of charities that help people to make charitable donations in the same way, who are over a certain age. So particularly if you're over the age of 55, 60, again, that can be an option for you all year round. But for the rest of us who are younger than 55, 60, then you may need to wait until will aid month around October, November. Or again, I wouldn't necessarily say just wait for that, for the sake of a typical cost of a will, which is somewhere between £140 and £240 for a single will, or £150 and £300 for a joint will, then I wouldn't delay making that decision. Okay, so I'm just going to go through now 10 top tips when you go about making a will. So go and grab a piece of paper and a notepad for these 10 tips, some of which I've already covered. So the first tip is to choose your executors, ideally that are younger than you, and make sure that you ask their permission first. So that's the first thing to take off your list. The second thing to decide is then to consider, if you're going to use a solicitor, my tip would be to ask them whether they work on a fixed fee basis or a percentage. Because if your estate is a considerable size, paying them a percentage of your estate on death is not going to be particularly great, and it could be very costly. That's less money to your beneficiaries. Tip number 3 then is to really think about and consider your beneficiaries. Who do you want to benefit from your estates? Tip number 4 is to think about choosing your guardians. So go back to the tips that I gave you around where do they live, what's their situation, do they have their own children, do your children get on with their children, what are their values as a couple or as a single person, what are their values, do they link in with your values as a parent? And worst case scenario, if you really can't think of anybody, just choose the best person as of today, and you can always change it later. That was tip number 4, wasn't it? Tip number 5 is to contact some local solicitors. Like after listening to this today, go and have a look at some local solicitors, maybe go into some of your social media platforms and speak to friends. Who have they used? Have they got any recommendations? If you're going to use a will writer, check and to see whether they're a member of a professional organisation. Because they're not regulated, you have less protection. So just make sure that you cover those points. Tip number 6 is, if you are over the age of 50, then there are lots of charities that will help you to make that will for free, or a charitable donation towards it. So go and check that out, and I'll pop a link in the show notes of the podcast for this as well. The tip number 7 is to keep your documents safe. So when you make a will, you'll get a draft version of it first, and then once you've read through that draft version, you're happy, you then sign that, have it witnessed by 2 independent witnesses, and then you would get a final copy of the will. Okay. Now, keeping that document safe is really important. Don't keep it in your house. Don't keep the only copy in your house. And the reason that is, it's a really silly thing, but if you had a fire in your house, your will's gone. If that's the only copy of your will, then that will has been destroyed. So always give a copy to your executor. Tell your family where your will is stored in your home so they can go and find it easily. And if you have used a solicitor, often they will allow you to lodge a copy of your will with them, either for free or for a nominal fee, like £15 a year, for example. So think about keeping your documents safe. The other thing that you can also do, which is tip number 8, is start organising your finances now. Start creating a central place where all of your financial information is captured, so that your executor knows what bank accounts you have, what savings accounts you have, what investments you have, what insurances you have. If you've got life cover, for example, that could be really beneficial in the event that maybe inheritance tax has to be paid or a mortgage has to be cleared. Now, for those of you that are in my Money Circle membership, we actually put together a PDF document in January of 2020 to help you store all of your financial information all in one place, so you can use that document. We've also talked about how you can use things like Trello boards to store your financial information. Now, you don't necessarily have to put account numbers on there, but you could at least have some columns in Trello, which is like this planning software that you can use, to at least have an idea of telling people, well, I've got a bank account with Barclays, I've got a bank account with HSBC, my life cover's with Aviva, my will is stored in so and so place. So think about, where is all this information right now in your home? If it's all over the place and not organised, how difficult is that going to be for somebody else to come and try and sort that out? So in an ideal world, take some time out in your diary to just form a spreadsheet or a PDF document or something that just gathers all of that information all in one place. And then tip number 9 would be, before you make a will, think about some of the things that you talked about today, but also write down a list of everything. So write down a list of what you own. Write down a list of what you owe. So your liabilities, do you have a mortgage? Do you have any credit cards? Do you have an overdraft? Do you have any loans? Write out a list of things that you own. So that's your property, your bank accounts, your savings, your investments, maybe some life insurance policies, maybe some pensions. Go and check out your pension beneficiary details. Make sure that your pension benefit is nominated to who you want it to go to. And that is as simple as just requesting a beneficiary nomination form, a beneficiary nomination form. That can often come from HR, or you might have a log-on area for your pension. Go and check out who your potential beneficiary is on your pension schemes. And then the final tip number 10, is to tell your family. So tell your family what your wishes are. Have these conversations with them. And I know they're not very nice conversations, but you can make it lighthearted. You know, you can, I've had plenty of conversations over the years about what music tracks, like I want to have Meatloaf at my funeral, like Heaven Can Wait. I don't know whether any of you know that song. And a few other tracks that I would really like to have at my funeral. And it just makes that whole process much less daunting, with a bit of humor, and it makes it much easier then for people that you're leaving behind. So have a think about, having that conversation with your family. If you don't want to have the conversation with them, that's fine, but at least tell them where your will is stored so that they can have easy access to that at the end. So I hope you found this training useful. If you're listening to us on the podcast, and you have any specific questions, then please feel free to come over to our Facebook page, The Money Panel, where you'll see a video of this particular podcast episode. And please feel free to pop any comments underneath the video, and I will come back and answer those as best I can. Obviously, I'm not currently a will writer anymore, but I do have connections with people that are will writers and solicitors. So if you do need a recommendation, please feel free to come over and contact me. And if you have any specific tips or examples or scenarios that you want to share, then again, please feel free to come into the video comments area, or again, you can come into my free Facebook community, Money Advice Expert for Women. And again, let's open up this conversation, this taboo subject, because there are two certainties in life, death and taxes. Let's talk about this so that we can come together to share examples, share our experiences, share some of the reasons why maybe we're not making wills, because I'm sure that if you're thinking that, somebody else is too. And this is about helping each other. Thanks so much for listening, guys. I hope you found that useful. And if this is an area that you want to know more about, then do come and join us in the Money Circle membership. We have many guest experts coming in talking about these kind of subjects and producing some really, really great detailed masterclasses. We actually have my own personal solicitor. She's come into the Money Circle recently and done some training on this specific subject. So if you do want to do some deeper dive work, then come in and join us. We'd love to have you in the community. And you can find more information at the link below, catherinemorgan.com/join now. See you soon.